Good morning, everyone. I want to make a quick video on piercing the corporate veil. And as you can see, I'm remote today from the office. I'm at the lake house, and that's what's in the background. And I wanted to do this while it was fresh in my mind because I was in court yesterday on a trial, actually a hearing in small claims court, Judge Poor in Washington Township. And it was very interesting because we had filed a motion to dismiss. We were ultimately successful on it, but this is the issue: is piercing the corporate veil. And we had a long hearing on this, and really piercing the corporate veil became part of the motion to dismiss, even though that wasn't really what the case was about and what the dismissal was about. So I want to talk about it because Judge Poor made quite a record in court about it, and he asked some very specific questions that I think are illustrative for you. And he is sensitive on it because he had recently had a similar case to mine, and ruled that there was no ability to pierce the corporate veil. The other party appealed that. The Court of Appeals affirmed what Judge Poor's decision was, and now it's on transfer to the Supreme Court. So he was going through that analysis a bit, and I think he was very thoughtful and very careful. And I agreed as an advocate, I agreed that he made the right decision, but also as an observer of the court, I independently think he made the right decision. So as you know, I'm going to quote from this one case the issues that are dispositive in determining whether somebody should pierce the corporate veil or not. And that would be number one. These are just 7 things. They're not exhaustive, but they are the ones court looks at first. Undercapitalization, absence of corporate records, fraudulent representation, use of corporation to promote fraud, commingling of assets and affairs, failure to observe required formalities, ignoring or manipulating the corporate form, and similar things like that. And what Judge Poor did during the hearing, and I thought it was very well done, he asked quite a few questions because my client had one entity that owned the real estate, and he had another entity that he used for other purposes, and the plaintiff had sued that second entity, the wrong entity. And the judge went through a lot of things trying to determine if there was really like a commingling between those two businesses or not. And my client did a real nice job in his testimony explaining the different purposes of those two companies. They were very distinct. The assets of the two companies were quite different. The income streams were different. The banking relationships were different. All of that was good. And the documents were signed, or named at least, and signed in the name of the entity themselves. One thing, a few things that could have been done better, I think, and that are helpful to us, so that there's absolutely no confusion, and I say this all the time: sign your letters and sign your documents as a corporate representative, for instance, as manager of the LLC. So you put your name, like mine, Jeffrey Jenks, comma, manager. Or if it's a partnership or you've been appointed an authorized agent or authorized representative, something like that. So your name, authorized representative, or manager, or your actual job title. That would be, I think, better. So we had most of that was consistent with our case, and all the documents were clearly in the corporate name, and the companies were validly existing and whatnot. So another thing that came up that I think would be helpful and was a little confusing is the use of email. So my client has one email, like most of us. We have one email address, and so the email included the name of this second company. And so the plaintiff tried to say, well, I thought it was the other company. I thought they were both the same, etc. It's not really a valid argument, but it did raise the idea that maybe you should have, and we talked about it afterwards, have a separate email for every company, and that it's clear, right? In this case, we would have said manager at companyname.com, right? Or whatever, or company name at gmail.com, something like that. So that it's clear that it's going to that other company, not to a commingling of the responsibilities or to a personal email, right? A lot of people have a personal Gmail account or a personal iCloud account or something like that. So that's a very key point that I think could have gone the wrong way if the other facts were not in our favor, right? We had so much, in our favor initially that, these little things are just tidying up and really making it clear. But the more you have in your favor, the more you are likely to succeed. Another thing that the judge asked about, and I might look at my notes, um, was the idea that the two entities would commingle responsibilities. For instance, did entity number two have any administrative responsibilities over entity number two, or perform any functions for entity number two? And this is again sort of the idea of commingling of responsibilities, like you might think of commingling your assets or your bank accounts, but it's even more than that. It's commingling responsibilities of the different companies. So I thought that was an interesting approach, and maybe it was from this other case that he had. Of course, always bank accounts. You want to keep that separate. It was clear that the plaintiff had made deposits into a separate bank account for the proper entity, so we got a dismissal on that issue. Another question he asked was, do you take a salary from each of these companies, yes or no? How do you get compensated? So it might be, you might say, well, I don't take a salary. I just take dividends and distributions and gains from the company when I sell real estate. That's fine. That's true. But maybe you ought to be, as a manager, compensated some way, even if it's a nominal salary. It depends on the value of the business, of course. But you want to look at, should I take a salary to perform the functions as the manager? Not just getting your profits out of the business, but as the manager, you're doing work and you have an independent responsibility. Therefore, you ought to get paid for that. So, and of course, that'd be deductible and create other tax benefits for you. So look at that and maybe take a salary depending on the income stream of your company. Make it proportionate to that. You don't have to take 100% as salary, but take something for your function as a manager of the company. And the last thing we talked about, it didn't come up in the trial, but I mentioned it to my client. I said, maybe you ought to have a business card for each of your businesses, of course, naming you as the manager, whatever your corporate title is, your email address for that company. And, you're handing it to them when you're renting the property or whatever, so that it's, again, multiple instances of delineating your representative authority for the company. It's not you personally. You don't meet them at your personal residence and conduct business. You meet at the location or at a business address. You handle your business card, etc. So those are a lot of some just different coloring of how to look at the corporate formalities and how they play out in a practical way to help you run your business better. I'll keep you posted on this case, and if I see the case on the Supreme Court coming down eventually, I'll try to notice it and remark on it again. But again, I think Judge Poor did a real careful job and a nice job, like all judges. I'm constantly, I'm glad I'm not a judge, right? They have a tough job to create the record and do it the right way. So very, very interesting cases. I appreciate the time with you. Good luck, and we'd be happy to help you with all your corporate needs.